Good afternoon here. This is Heather Van Wild, Raindrop Works. Um, just a little bit of housekeeping before we get started here. I know I've been pretty quiet the last few weeks with everything going on. Some of you might have heard a few weeks ago one of my cats passed away, which was kind of a mess. And then right after that, I got the one of the sicknesses that's been going around Portland, um, which I'm still on the tail end of recovering from. And yeah, I'm hoping in the coming days and weeks to start trying to get more stuff put out. Working on playing catch up on a few different court cases, but we're not here to talk about those court cases. We are here to talk about Measure 114. There is the sweeping gun control legislation that was done through a voter ballot initiative in this last election, and just barely squeaked through. It was one of those things where the Portland area largely supported it. The entire rest of the state didn't, and it passed with 50.65% of the vote. It was only a 25,000 vote difference. And I do apologize if you hear construction noises. The people that are doing nonprofit work outside the back of our house, they're working today, and hoping that the noise is minimized. We've tried to do what we could to cut that down. So anyway, as we have seen after the election, there was a lot of pushback to 114. Even beforehand, we spoke out on our platforms about how it was very poorly worded. A lot of things that it was trying to force the state or individuals to do without any clear direction on how to do it, no funding for new programs, and it caused a lot of confusion, fear, hassles. I know people who are now stuck, with possibly tens of thousands of people that are trying to get a firearm in the state stuck waiting on background checks, and it's almost like there's more people getting added to the list faster than the state can process them, with an understanding that something could happen in the courts that all of a sudden all those people are automatically denied because of this ballot measure. So that being said, one of the larger things that just came out today was a injunction, which is or a temporary injunction. Basically, when you have a civil case like this where you want to compel action, then to start off with a restraining order, which temporarily prevents something until both parties can make their case to a judge. Then you go for a temporary injunction, which is where the judge will look at the evidence that's presented and try to determine whether there's a good chance that the person who is seeking the injunction has a good chance on succeeding on the merits of their case. And then it can cause a stoppage of certain things to happen until a case is done. At which point, after everything's adjudicated, you may have a permanent injunction which compels a particular thing to happen. A good example that we have here is summer of 2020. We had issues with Portland police assaulting journalists as well as protesters, and from the George Floyd protests. Some of the journalists went to the courts to say that this is illegal. We need something in writing holding the police to not do this. And there was a temporary injunction in early July 2020 to say that if you have these items, that they said in this case, indicia of being press, press pass, clothing that clearly identifies you as press, things like that, that unless they were observed committing other crimes, police were supposed to leave them alone. And that was a temporary injunction that held through the rest of the court case. Now, that particular case, I think it still has not been resolved, so that temporary injunction is still active 2 years later. So this is basically what we're looking at here, because this was a short notice. This needs to be done quickly because we're looking at constitutional violations. Now we have Judge Ratio, I believe is how it's pronounced, but I'm not 100% certain on it, presiding judge in Harney County, dealing with preliminary injunction on ballot measure 114's magazine capacity component, which I will go into later, the specifics on that. It says, parties, the court will issue a preliminary injunction under Oregon Rule of Civil Procedure 79A on ballot measure 114, section 11, known as the large capacity magazine prohibition, until a full trial can be held on the complaint for declaratory and injunctive relief. Just real quick, here is the measure 114 text that came from Ballotpedia. Just going down really quick. Just want to lay out exactly what was going on in section 11 here. This is going to be talking about detachable magazines versus fixed magazines. A large magazine they defined as a fixed or detachable, and whether it's permanently attached to the firearm or something that could be added in. So you could be talking about a shotgun that has an internal magazine that can take a bunch of shells. You could be talking about a magazine clip for a pistol or a rifle. They also suggest belt, drum, feed strip, helical feeding device, or similar device, including any such device joined or coupled with another in any manner, or a kit that has an overall capacity of, or that can be readily restored, changed, or converted to accept more than 10 rounds of ammunition, and allows the shooter to keep firing without having to pause to reload. and then they have exceptions here. That an ammunition feeding device permanently altered so it's not capable of accepting more than 10 rounds of ammunition. An attached tubular device designed to accept and capable of operating only with 22 caliber rimfire, or a tubular ammunition device that's in a lever action, which is one that, my understanding, when you fire, you have to pull the lever down and pull it back up to load the next round. So then they lay out here that a person commits the crime of unlawful manufacture, importation, transferring large capacity magazines, if they do it on or after the effective date of the act. And parts of it don't apply for 180 days. Licensed gun dealer has within 180 days, and dealing with how gun dealers would handle their inventory. And there was a lot of problems that came from the way that this definition was done, because firearm magazines are frequently taken apart as part of their maintenance process, and the only way that they could really fit this law would be if it was like physically too short to hold more than 10 rounds. This section B here was one of the big problems that we ran into. Any large capacity magazine permitted to be manufactured under paragraph A of the subsection after the effective date shall include a permanent stamp or marking indicating large capacity magazine was manufactured after the effective date. So, new magazines that were allowed to be made, such as for law enforcement or military purposes, they would have to be stamped. Okay. But what about for magazines that were made before that? Basically, everything that I have heard has suggested that it would become the burden of the person owning the magazine to be able to prove that they had the magazine before the measure took effect. And if you couldn't prove that, then you're automatically guilty of this, which it's a Class A misdemeanor, which is one step down from a felony. Just owning this magazine. So this part has a lot of problems. I know people who have a lot of magazines, have had magazines for years, and they don't have receipts for them because they had no idea that 5-6 years down the road this ballot measure was going to come through. Even with a receipt, how do you prove that receipt matches this magazine? There's a lot of questions that I could easily see from this. And this is part of why there was a lawsuit going after a lot of these parts. So most of what happened today was specifically about Section 11, because other things will be handled separately. This was just too large of a case to be able to handle it all at one time. And as you'll see, they're going over other parts of it in order as best they can, with more hearings coming in the next month, and then the ongoing build-up for the trial itself. So, the court says that they'll maintain the temporary restraining order under Oregon Rules of Civil Procedure on sections 1 through 10 until the state provides notice it is ready to deploy a permit-to-purchase program. That particular program was the idea that people have to pay for a permit periodically to be able to purchase a firearm, and have to go through a safety class that the person wanting to purchase has to pay for. So, this is really digging into the pocketbooks of people who want to have a firearm, which, will have an inordinate negative effect on people who are lower income or otherwise marginalized communities. If you are already having difficulties with finances, that's just going to make things even worse. That's one of the problems that I definitely had. Now, I've already had other issues with the existing rules that we've had on the books, because they've ended up preventing me from being able to go into a store and purchase a firearm, because the way that the law is written, it's running afoul of other laws. So what they're saying here is, because the state has said repeatedly they are not ready for this permit program, they could not get something together. The judge is now saying, take the time that you need to do this properly. Once you have the system ready, come tell us, and then within 10 days we'll go back and reevaluate if this program is actually ready to be constitutional. And then if it passes constitutional muster at that point, then they'll start the permit program. And I mentioned the court cannot rely on a federal stay. There is a separate analysis and identified right under Oregon law. The court adheres to its oral findings from December 6th and 13th, 2022. Defendants are granted a hearing on December 23rd, 2022 regarding the Charleston loophole portion of Ballot Measure 114. Defendants will identify in a written notice the operative language at issue for that hearing by Friday, December 16th at noon, which is tomorrow. The Charleston loophole is a loophole where if a background check for a firearm has been pending more than 3 days, the FFL, which is the firearm seller, has an option to release the firearm anyway. They're not required to, but they have an option to. And there are some firearm sellers who will go ahead and do that, and there are others who won't. The reason why it's called Charleston loophole is one of the mass shootings in Charleston was by somebody who got their gun after 3 days with a pending background check and then used it to commit mass murder. That's one that personally I can see some validity to trying to close. I can see a way where it's valid. But on the other hand, our current background check system, even without the new permitting system and everything, is so backed up that we could be looking at months for a background check to go through. And that to me is highly questionable. So like I said, there'll be filings tomorrow where the parties will, kind of lay out where they have problems with the language, and then on the 23rd there'll be the hearing on that. The court is segregating each matter because of Section 12 of the ballot measure, requiring severability in case of the finding of unconstitutionality of a provision. Basically, this just means that the measure said, if this one section of the ballot measure is found to be unconstitutional, the rest still stay in effect. So everything has to be done separately because that's the way that it's written. Turning to ballot measure 114, section 11, the prohibition on large capacity magazines, the findings in this opinion letter are not binding on the final legal and factual determinations after a final trial on the complaint. The analysis is limited to findings on the motion for a preliminary injunction. The court must find that the facts as applied to the law show a clear conclusion under the factors of ORCP 79. The clear conclusion must find that the plaintiffs have established a likelihood of success on the merits, which is weighed against other factors under ORCP 79. So what they're saying here is, what the judge is saying is, based on what's going on now, or based on what's been presented to the court, it looks like there's a decent chance that this is going to be found unconstitutional. Melissa's saying you'd think the long delay for background checks would maybe create job opportunities to reduce the wait. And that's a possibility. I'm not sure entirely how the background check process goes. I think that's done through the state. And if so, then that's, you're going to have problems with getting state employees, onboarding them, training them, all of that stuff. I know that there's also, I've heard complaints, and keep in mind, I'm not the most up-to-date on gun laws, because it's not something that I've been able to, avail myself of at this point. But some of it I know is issues at a federal level with some of the background check stuff being forced by law to not be easily, digitized and easy to work with, which could be part of what's slowing it down. I'm not 100% sure where those delays all are coming from, other than there has been a huge fire sale on new firearm purchases as a direct result of 114 passing as a ballot measure, because people saw that, if this gets upheld, whatever we can get before it goes into effect may be all we ever get for some of these firearms. So we have factual findings. Findings 1 through 23 are from the pleadings and attached exhibits for the temporary restraining hearing held December 6, 2022. Findings 23 through 37 are from the preliminary injunction hearing and associated exhibits held on December 13, 2022. Now, I did not see any of those hearings, so I don't have a lot of the specifics. I know that there was a lot of filings of declarations and things that are in the court docket. I didn't actually look at them yet. If that's something that people here have more of an interest in, I can look at pulling stuff down and adding it into our new court record system that we're hosting. If that's something that there's an interest, let me know in the chat or in the comments, and we'll look into it. So we have here, all these findings are considered by the court. First off, at the temporary restraining order hearing, plaintiffs called a credible factual witness, Ben Calloway, a Harney County firearms dealer with a federal firearms license, or an FFL. Mr. Calloway testified most firearms currently sold can be modified to hold more than 10 bullets by readily accessible kits and extenders, meaning most commonly owned firearms, including shotguns and handguns, may not be legal for sale under 114 pursuant to the language in Section 11 1DA. Exceptions to the restrictions on large magazines, including a ammunition feeding device that has been permanently altered so it is not capable now or in the future of accepting more than 10 rounds of ammunition, because the firearms will have no available operable magazines under the prohibition. Basically suggesting all these guns are going to be useless because there's no magazines that can be made legal. 2. In Oregon, 593 people died from firearms in 2020. Defendant's brief for mandamus, page 4 of said declaration. According to Oregon Health Authority, there were 40,239 deaths that year. Aggregated, there were 158 deaths by homicide and 835 deaths by suicide. Obviously not all by firearms, since we're talking about 1,000 deaths and 600 died from firearms. On this reference, Oregon Health Authority's death data from the state of Oregon. Death by suicide would not require a large magazine. 1 bullet. In 2020, 122 of the homicides were with a weapon. See an MSN article, over half all homicides in Oregon are committed with a gun. 70.5% of those weapons were firearms, meaning there were 86 homicides with a firearm. The number of rounds number 3, the number of rounds commonly needed by individuals to defend themselves has not been systemically tracked nor has the number of rounds fired by individuals in self-defense. The Marshall Declaration and the Declaration of Lucy P. Allen. Allen found from the literature that 0.3% of 736 instances of self-defense used more than 10 rounds in the encounter, since more than 10 shots were fired during the event. 56% of all acts of self-defense occurred in the home. Large capacity magazines are estimated to be used in 3 out of 10,000 acts of self-defense. None of these specifics are organ specific, except for some information exhibit B of the Allen Declaration. I have to admit, I kind of question that, because we just had the FFL point out that so many firearms have no way to be used without what they would call a large capacity magazine. So I question 3 out of 10,000. Even a handheld pistol can frequently have 12, 15, 19, plus 1 in the chamber. Anyway, number 4, Exhibit 1B determined there were 179 recorded mass shootings in the country from 1982 until October 13, 2022. 2 of these mass shootings occurred within Oregon, causing the tragic loss of 13 lives, along with 24 others injured. Thurston High School in May of 1998 and Umpqua Community College in October of 2015. The declaration was prepared for California litigation, and California has no state constitutional right to bear arms. It's number 5. Number 6. The court finds the Colt multi-shot revolver was developed in the 1830s and appeared in the pre-Civil War West. This was from a Marshall Declaration. I'm not necessarily sure the relevance of that. Number 7, Oregon first restricted machine guns in 1933. Oregon Law 488. The limitation was on, quote, fully automated weapons described as a weapon of any description by whatever name known, loaded or unloaded, which is designed or modified to allow 2 or more shots to be fired by a single pressure on the trigger device. The definition is still operable in Oregon under ORS 166.201 Section 6. ORS 166.272 does not allow for the possession of such weapons. So we've already established that automatic weapons, quote-unquote machine guns, are illegal in Oregon. So we're only focused on semi-automatic, single-fire, things that at the very least you have to squeeze once each time. So there were a couple of comments on here. Machine gun means a weapon of any descriptor or description by whatever name known, loaded or unloaded, which is designed or modified to allow 2 or more shots to be fired by a single. Okay, they're reading these are the definitions in law. 166.273, unlawful possession of machine guns, certain short barrel firearms and firearm silencers. A person commits the kind of unlawful possession of a machine gun, SBR, short barrel shotgun, or silencer if the person knowingly possesses any of them. Unlawful possession is a Class B felony. A peace officer may not arrest or charge a person for violating subsection 1 of the section if the person has in their immediate possession documentation showing that it is registered as required under federal law, which is getting a tax stamp from the from the ATF. And I know people who have the tax stamp for a silencer. It is an affirmative defense to a charge of violating subsection 1 of this section of the was registered as required under state law. So, basically, you have a pistol that has a silencer. If that's all it is, it's illegal. But if the person has the tax stamp with the paperwork from the ATF, then the police are not allowed to charge for that. And even if they did, here's the tax stamp, is your affirmative defense. So, um, now here's where we start to get into problems with some stuff here. Number 8, the court finds the Spitzer Declaration conflates magazine capacity with the firearm actions, to wit, automatic versus semi-automatic, severely limiting its value to these proceedings. And this is something that seems to come up very frequently in gun control debates. People that are in favor of gun control having difficulty understanding how firearms work. You know, we see big scary AR rifle and think that, oh, that's a assault rifle machine gun, and no, it's it's still a semi-automatic rifle. You squeeze the trigger once, it shoots one bullet. So it seems that this particular declaration made a lot of factual errors, which is not good for their case. Number 9, since 1949, when the first mass shooting occurred, there have been 30 mass shootings resulting in 10 or more deaths. None occurred in Oregon. Of the mass shootings with fatalities of 14 or over, the assailants used large capacity magazines. There have been 13 mass shootings with 14 or more fatalities since 1966. There have been 69 mass shooting events involving the death of 6 or more people from 1990 to 2017. 64% of those events involved large capacity magazines, or 44 over that 27-year period. The exhibit states, although 69 is a horrific number of instances, for statistical purposes it is a relatively small number and limited the power to detect significant associations. Moreover, because of suboptimal statistical power, there is also the possibility that the magnitude of the effects detected was overstated regarding the use of large capacity magazines in mass shootings. Further, the impact of individual state firearm laws is reduced by the fact that guns often move across state lines, occasionally purchased in locales with more permissive law and taken to states with more restrictive laws. And that's not something that's going to change in Oregon, even if 114 goes into full effect like it is. All you have to do is go to Idaho, pick up a gun there where they have very lax gun control laws, and then bring it over. It only becomes a problem for you if you get caught with it. And that's not the kind of thing where police are going to be pulling everyone over looking for guns, because that's warrantless search and seizure. Number 12, in total 1,460 people were injured or killed over the 37-year period in mass shootings from 1981 to 2017. Harney County, where this case is being heard, has a population of 7,495 people. In other words, over a 37-year period, they're suggesting that a number of people in the country equivalent to a quarter of this county's population were injured or killed. 7,500 people versus 300 and some odd million people across the country. Number 13, mass shooting fatalities as a particular type of gun injury event account for less than 1% of all gun deaths. And just that, guns are not, guns may be a problem, but mass shooting is a very minor, and this appears to be, of all gun deaths, not of all shootings, which means that the number of events that would have that would be even lower, because, if you have 5 deaths, well, that's one event versus 5 single death events. Number 14, other types of gun violence, such as suicide, domestic violence, homicides, and red flag order violations, are not responsive to large capacity magazine bans. Again, if you're going to, harm an intimate partner or yourself, Honestly, you only need 1 or 2. Number 15. The remainder of the study only looks at fully automated weapon bans and cites by the author of the declaration as making claims of public policy benefits from large capacity magazine bans. The study stated it could not create a distinct statistical evaluation of whether such bans have an independent impact on mass shootings from the restrictions of the actions of firearms. Again, this seems like a pretty weak case because we already have a ban on fully automated weapons. So the study that this particular declaration used to try to justify what they're asking for wasn't even relevant. Marshall Declaration has no description of the effects of large capacity magazines in the 593 firearm deaths in Oregon in 2020, though notes that 455 of the deaths were from suicide, which, again, we've said that large magazine has nothing to do with that. So now there's, you're looking at questions of 140, or no, like 148. Marshall Declaration is a study heavily relied upon by the defendants entitled Evidence Concerning the Regulation of Firearms Design, Sale, and Carrying on Fatal Mass Shootings in the United States. The study indicates there were 604 mass shooting events involving 4 or more fatalities from 1984 until 2017, equaling 2,976 homicides. Nationally, the annual rate of mass shooting fatalities per 1 million population nationwide was 0.36 per 1,000 population. So, 3.6 per million. The results for the researchers found no evidence that concealed carry laws, assault weapon bans, prohibitions for domestic abusers, and violent misdemeanors, or point-of-sale criminal background checks were associated with the incidences of fatal mass shootings. And these are all things that are usually touted as more common sense gun control or gun reform things. Saying that the things that most people accept would make us safer individually don't do anything about mass shootings. Further inferences cannot be made that large capacity magazine bans have an effect on casualties, only that there may be such an inference. Even though there is evidence that large capacity magazine bans and firearm licensing has an effect on mass shooting incidences, there are large confidence intervals. Statistically, that's kind of statistic thing saying that there's a big margin of error, which makes the data a little bit harder to confirm its validity or its usefulness. The final conclusion of the article on large capacity magazines is striking to the court. Large capacity magazine bans also seem to reduce the incidence of fatal mass shootings. The court finds the article states there are no scientifically certainty large capacity magazine bans have an impact on fatalities or casualties. Also referencing Marshall Declaration, statistical significance of the large capacity magazine ban on mass shootings is variable. So point 17 here, and coming up to it is basically suggesting that if you're trying to say that large capacity magazine bans help prevent mass shootings, the science isn't there to reliably support it. It may be there, but we need research. And in most cases, it doesn't do anything because large capacity magazines, the shooting incidences aren't going to be affected by whether the gun has 10 or 11 rounds. Most times you only need, 2, 3, 4 shots to end your event. Number 18, the mean annual rate of mass shootings in Oregon per 1 million population is 0.06, and of fatalities is 0.3 per million of population. The data is not linked to large capacity magazine usage. Number 19, of importance in other parts of this litigation, the findings of the study suggest that the most common policy prescriptions offered by advocates on each side of the debate over gun control, comprehensive background checks and assault weapon bans on one side, and so-called right-to-carry laws reducing restrictions on civilian concealed carry of firearms on the other side, do not seem to be associated with the incidence of fatal mass shootings. In other words, nothing anyone is suggesting is going to do much to fix mass shootings. The Marshall Declaration does not apply to a section does not apply to large capacity magazines. The Declaration of Brian Busey states that, quote, many widely available guns are designed with universal magazine acceptance. Many handguns can accept a magazine with 15 to 20 plus rounds. Firearm manufacturers can easily modify a high-capacity magazine into one that will accept only 10 rounds. The most popular self-defense firearms in history, a Colt 1911 style pistol, came with standard magazines of 7 to 8 rounds. The model can be adopted by interchangeable magazines to hold more than 10, and additional magazines can be purchased at a minimal cost. That seems to be something that goes that may go in favor of the magazine ban, because the most common home defense rifle or pistol is a small capacity, and if you need more, another magazine is cheap. Now, magazines might get more expensive if only certain ones are allowed anymore, but that would be speculation on my part. Number 22. Further, buying multiple magazines and maintaining a large supply of magazines is and has been encouraged by firearms manufacturers and firearm retailers. Additionally, there is a well-known sales spike for magazines whenever regulations are implemented, as consumers anticipate laws or, quote, grandfathering, with purchases meant to ensure legal supply for a large period of time. Most gun owners purchase several magazines for each gun that they can easily modify. And this comes back to what I said when I was going over the ballot measure text itself. You know, there's been gangbuster sales now of people buying up firearms and magazines and everything because they know that if this goes through as written, they may never be able to get this part again. Alright, the deaf cat is very chatty. Yes, you are. You know, so it's, you either get it now or you'll never get it. And we've seen this across the country every time a state or, you know, national legislation suggests doing things with background checks or firearm purchases. All of a sudden, all the guns are brought up. It sometimes I wonder if gun control isn't a marketing campaign by firearms manufacturers. I don't think it's really the case, but if somebody did a WikiLeaks and found emails that said that proved that it totally was, I'd believe it. Anyway, number 23. Of note for the preliminary injunction question, a, quote, recent example of this well-known reality includes Freedom Week in California, in which a court allowed the sale and purchase of large-capacity magazines during 1 week in spring 2019, resulting in massive sales spikes. The court finds that deliberate action from the court is warranted to not create a whipsaw effect so described. So, my understanding from Freedom Week is a similar, I think this was a large capacity magazine ban in California, was passed in the state, was briefly blocked by the courts, and then a week later they changed course and upheld the ban. And in that 1 week, a lot of people bought stuff. And here this judge appears to say that he doesn't want to, he wants to make sure that things are done in a safer manner to prevent that same kind of knee-jerk reaction from the general public. So number 24, ballot measure 114 is impacting the ability of firearms dealers to stock their stores. Midway USA, a national distributor of firearms, is issuing the following, quote, order contains restricted products. These products cannot be included in your order due to the following. Oregon has restricted the sale of magazines that have a capacity of more than 10 rounds or those that can be adapted to hold more than 10 rounds, e.g. those with a floor plate or end plate. Plaintiff's PI8 or preliminary injunction hearing exhibit shows the same result with other manufacturers. People that I know have personally run into that exact issue where, you know, even like the night after the election, before anyone even understood when the measure would take effect, stores were starting to stop selling magazines. Later on, stores would say that, you know, if after a certain date they would stop selling, and it was weeks before the actual start date of the measure, because out of an overabundance of caution, because if they if they send out a magazine and it gets held up in shipping and it gets to somebody too late, they could potentially face criminal actions and lose their federal licenses. So this was definitely causing problems for consumers, for manufacturers, for the sellers. A lot of uncertainty and a lot of questions as to the constitutionality. Number 25, California's restriction on large capacity magazines is much narrower than ballot measure 114. That seems kind of relevant. I mean, California is known for its strict gun control laws. And we were making ours even stricter. Number 26, defendants offer an exhibit showing firearm manufacturers do offer magazines of 10 rounds or less that are California compliant. Most appear through testimony and exhibits to be capable of ready modification to increase capacity. That's probably going to be a pretty key point. You know, because you could, in Oregon, you know, under the ballot measure text, they did say that if it's easily modifiable, then it's still not legal. And this also seems to be a problem with the California measure. If it's easy to take an under 10 round magazine and make it a larger one. Now, I didn't hear the actual hearings on this, but I've heard that the judge actually pointed out, you know, Oregon is generally a rainy place. You need to be able to disassemble metal gear to oil it and clean it and everything. If you can easily take apart a magazine to clean it, that often makes it easy to modify it. And that was kind of striking to me, and it's like, yeah, that actually kind of makes sense. Number 27, Mr. Calloway credibly testified at the preliminary injunction hearing that most, if not all, current magazines are readily adaptable or easily modifiable within a period of seconds with a hand drill or pocket knife to be able to hold more than 10 rounds with all popular gun brands. The defense expert, James Yergalitis, did not dispute that testimony. So even the people trying to support the ban couldn't refute that. In fact, he stated, quote, anything is possible for modifying magazines with a technical skill range of little to some. The adaptability of magazines includes just taping two magazines together to create one with a 20-round capacity. I think what they're suggesting, and this used to be a trope in old war movies with like an M16. You would pop the magazine out, you'd have two banana clips, you know, electrical tape together, you pop the magazine out, just flip the magazine and put it over, and you're ready to go. Now, technically, you're having to reload, But if you're familiar with the muscle memory and the action, that's a matter of a second or two. Number 28, Mr. Calloway also testified that fixed plates on magazines diminish the life of the magazine since they cannot be maintained. This is going back to how easy it is to modify and how damaging to the magazines it would be to remove their ability to be modified. The defendants raised the length of magazine life as part of their analysis of why ballot measure 114 has no impact on current large capacity magazine owners when they tried to say that replacement magazines are cheap. Mr. Calloway described that the normal approach of cleaning magazines for safety and functionality is to remove the end plate after every second use to clean out the grime and oil the spring mechanism. He testified it was not possible to do the same cleaning process with fixed end plates, thus significantly diminishing the product's use potential. I'm not sure if they'll go into this, but it sounds like, if this is for safety and functionality, if you can't clean the magazine, you're running risk of, causing damage to the firearm, which could cause damage to the wielder. And then you've got more injuries and possible deaths coming from what's supposed to be a safety thing. Mr. Yurgalitis described using air compression, cleaning fluid baths, and ultrasound technology to clean these mechanisms, a process which is time-consuming, requires special equipment, and is expensive in comparison to detachable faceplate cleaning techniques, and is not as effective as the detachable end plate design. Right now, you need, a screwdriver, a rag, some Q-tips, basically, for cleaning and oiling. Instead of having to, canned air that would be more likely to compact dirt and grime. Cleaning fluid baths, a big bucket of possibly caustic cleaning chemicals. Ultrasound technology, an ultrasound bath where you need a special machine to put the magazine in. I definitely see a lot of problems there. Number 29, replacing magazines, according to Mr. Calloway, generally costs $40 to $50. The process creates a cost prohibition to owning firearms, particularly for indigent. If you're having to replace a magazine, say, every 10 fills, bullets are already expensive. Having to drop an extra $40 or $50 for a new magazine every couple hundred rounds, especially if you go shooting at a range. I know people who go through that in a single range visit. Number 30, Mr. Yurgalitis noted there are magazines for the commercial market with magazine restrictions. The other jurisdictions do not have adaptability restrictions, and this seems to be part of what is making Oregon so much stricter than California. As he testified in direct testimony, there is, quote, no magazine on the market that cannot be modified because of the floor plate. It's suggesting that the market would have to create a whole new type of magazine designed to be disposable for Oregon because we're not letting people disassemble and maintain their own magazines anymore. Now, someone who's a big advocate of right to repair, that's pretty screwed up in my opinion. Just that right there. Number 31. Dr. Brian DeLay testified the development of firearms was significant between 1860 and 1872. He also submitted a separately filed declaration on December 12, 2022. The testimony was crafted to eliminate the time and effort made in that development. He testified that during Polk's War of 1846 to 1848, multi-capacity revolvers and rifles were in use and for sale to the private market. Emigrants on the Oregon Trail had the same types of firearms. Large-capacity magazine prototypes were in development since 1580, though not generally in the marketplace, largely due to a lack of functional stability for the use by the public. But, quote, almost certainly the framers and adopters of the Oregon Constitution would have been aware of those developments and the ongoing developments in firearm technology. This reminds me a lot of, I think it's the Rural Test, is something that just came out of the Supreme Court in their last their last session, suggesting that the founding fathers, of the country, now granted this is of the state, but this was after the country, that we needed to look at what their beliefs were at the time that they wrote those things. Now, and again, large capacity magazines in development since the 1580s, that was, almost 200 years before the U.S. was founded, and even longer before Oregon was first settled, much less made a state. So it's not like this is something that, oh, they didn't have anything like this back then. It's definitely something that they would have known about, and if they had seen an issue, they would have said something. So the Koppel Law Review article comes to the same conclusion about the multi-round technology and public knowledge around statehood, as does the Helbrinsky Declaration on the technology of that time frame. All these experts agree that there is no clear distinction between private and military use at the time of statehood. Dr. DeLay did testify that most private gun manufacturers were angling for military contracts, but would sell any firearm to private citizens if they could afford one. Private citizen purchases supported their own self-defense and defense of the state in the form of militia activities. Yes, we don't have militias anymore, but that seems to be less of an issue. Meriwether Lewis, as in Lewis and Clark, brought his large capacity magazine weapon for his expedition. The Hornback exhibit bolsters this factual finding regarding the broad scope of firearms used by early leaders and settlers in Oregon. Number 32, Dr. DeLay testified there were no historical antecedents in the law banning any type of firearm in 1857 to 1859. Helbrinsky also finds there were no historical antecedents. DeLay and Helbrinsky agreed laws banning particular possessions of types of firearms did not begin generally until the 20th century, post-dating statehood. Number 33, magazines are an integral part of firearms. Limiting magazine sizes has a direct impact on who can use a firearm in self-defense. Weaker individuals cannot use large caliber firearms due to the recoil impact for self-defense. Weaker individuals compensate for the inability to use larger caliber ammunition with large magazines. Basically suggesting, I haven't actually tried. My shooting experience from when I was in the military was M16, so 223 ammo. I've never fired a 357 Magnum. A lot of stopping power. Could also knock me on my ass if I shoot one. Someday I'd like to go to a range and just, find out. But if I don't have the grip strength to properly hold and steady the pistol as I'm shooting, then either I can't use the larger firepower, so I need to possibly use more of a smaller round, a 22, which has much less stopping power and may take more shots to incapacitate someone. But if you have someone that can, say, still move around with 2 or 3 shots from a Magnum, how many rounds of a 22 is that going to take? 10 may not be enough. This is, me talking out my butt here. I don't have the numbers for it. I can see where they're coming from with this. So, number 34. Unlike Declare and Busey, Declare and Hanisch states that large capacity magazines are in fact ubiquitous. They're all over. Number 35. The article by William English, PhD at Georgetown University. 2021 National Firearms Survey. Updated analysis including types of firearms owned. Expanded report May 13th, 2020 is of note to the court's findings on the question of ubiquitousness. Number 36 looks at Vermont statistics. In Vermont, 30% of the state's residents own firearms. Of those 30%, 29.3% have used a firearm in self-defense, in which 45.9% of the incidences were against multiple assailants. And this increases what I was talking about with people who need a lower caliber weapon. If you need, say, 2 shots from a magnum to incapacitate one person, but you need 6 in a 22 caliber, well, now you put a second person in. Oops. Now you need 12. Uh-oh. Number 37. The current rate of gun ownership in the country is 31.9%. Of that group, 31.1% have used their guns in self-defense. Almost a third of the country owns guns. Almost a third of those have used them in self-defense. You're talking 1 in 9, 11%. 10 to 11% of the U.S. population has used a firearm in self-defense. In Oregon, 38.3% of citizens are estimated to own firearms. Of those, 49.8% are estimated to own magazines that hold 11 plus rounds. So you're talking about a full 20% of the state's population looking at legal jeopardy if they can't affirmatively prove that the magazines that they have, they legally had before some sort of a ban. So with all these facts, the role of the judiciary is to determine whether ballot measure 114 section 11 exceeds the legal limits of the people's authority under the Oregon Constitution. Article 1, Section 27 analysis. The Constitution provides the right of the people, quote, to bear arms for the defense of themselves and the state. As pointed out by the defense, the Oregon Constitution, quote, has content independent of that of the federal Constitution. To which the judge puts a note in here, while this court disagrees with some of the factual conclusions of U.S. District Court Judge Karen Immergut, who I believe is hearing some of the cases in federal court against this measure, those conclusions, which are not binding on Oregon state courts, she is analyzing the measure under Second Amendment jurisprudence. This court does not reach that analysis since there is a clear preliminary showing that the measure is constitutional under Oregon Constitution Article 1, Section 27 by reading the provision and Oregon jurisprudence related to the constitutional protection provided to the citizens of Oregon to, quote, bear arms for the defense of themselves and the state. So therefore, any irreparable harm of ballot measure 114 must be considered separately under Oregon law and is not dependent on a federal determination. So we've got 2 different sets of constitutional laws that are coming up here. If the federal court says that this runs afoul of the Second Amendment, then it's blocked that way. Even if they say that it's okay under the Second Amendment, it still has to it still has to be validated against the Oregon Constitution. And that's where the Harney County judge here is focused on. So the Oregon Constitution must be at least as protective as the federal Constitution on any matter of constitutional right. To which they reference the Second Amendment to the U.S. Constitution reads, quote, a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. Plainly read, the Second Amendment right to bear arms is captured in the and the state language of Article 1, Section 27. So the Oregon Constitution must be at least as protective as the federal Constitution. If it is not, the question becomes, does the United States Constitution have a more protective right, thus making the Oregon provision unenforceable pursuant to supremacy clause? If the U.S. Constitution says that something in the Oregon Constitution is illegal, it doesn't stand. We saw this with gay marriage a while back. Oregon actually had a constitutional amendment. I'm not sure right now if it's still in the Constitution or not. It's saying that marriage was between one man and one woman. Now, Agrafel came out. The courts at the time said, no, that's unconstitutional. It invalidated part of the state constitution because they had priority. According to Honorable Jack Landau, retired Oregon Supreme Court Justice, quote, in some cases, the court adopted a historical or originalist approach, as in State v. Kessler. That case involved the meaning of Article 1, Section 27, which guarantees the right to bear arms. The court observed that federal court decisions construing the Second Amendment guarantee of a right to bear arms, quote, are not particularly helpful. Turning to the meaning of the state constitutional guarantee, the court declared that its task was, quote, to respect the principles given the status of constitutional guarantees and limitations by the drafters. The court set out a history of the provision from its roots in the English Bill of Rights of 1689 to colonial American fears of standing armies and concerns for personal safety to the state constitution of Indiana, from which the Oregon guarantee was borrowed. In the end, the court guaranteed that the arms that the state constitution guarantees a right to possess consist of those that would have been used by 19th century settlers for personal defense and military purposes. And this was from an introduction to Oregon constitutional interpretation in the Willamette Law Review, spring of 2019. The judicial review concept of precision in the drafting of the Constitution of Oregon started in 1863. Quote, if the framers of the Constitution had intended to limit them to $100, they could and certainly would have used different and more appropriate language to embody their intention. I'm not entirely sure what $100 has to do with this. I think it might be referencing a different case. Nolan v. Costello. State v. Hirsch similarly cited a range of modern treatises and articles on the historical origins of the constitutional right to bear arms, as well as more contemporaneous sources, including writings of the framers of the Second Amendment, on which Article 1, Section 27 of the Oregon Constitution is a decedent. This is quoting State v. Hirsch in 2005. We must discern the intent of the drafters of Article 1, Section 27 and the people who adopted it. Landau states, a constitution is dependent upon ratification by the people. Its language should therefore be considered in the sense most obvious to the common understanding of the people at the time of its adoption. This court is bound by the interpretation of the Oregon Constitution by the Supreme Court and the Court of Appeals of Oregon. The current constitutional interpretation under Article 1, Section 27 is found in State v. Christian in 2013. First, the Oregon Constitution allows for reasonable restriction on ownership of weapons that promote public safety. Second, the reasonable restrictions cannot unduly frustrate the right to bear arms. They're quoting here, the legislature may specifically regulate the manner of possession and the use of protected weapons to promote public safety as long as the exercise of that authority does not unduly frustrate the right to bear arms guaranteed by Article 1, Section 27. The Oregon Supreme Court, in its early interpretations of the Oregon Constitution, asked the lower courts to consider, quote, what did those conservative pioneer citizens have in mind? The holding limits the inquiry to a facial challenge of the constitutionality of a statute. The Supreme Court indicated that total bans on types of weapons and firearms used for self and state defenses violates Article 1, Section 27. Quoting State v. Delgado, the problem here is that ORS 166.501 Section 1 absolutely prescribes the mere possession or carrying of such arms, switchblades. This the Constitution does not permit. And I've recently learned about the media outcry about switchblades, stoking unreasonable fear in the public. Anyway, the evidence shows that the distinction the defendants are trying to draw between firearms and magazines is a fiction. Firearms do not function without magazines. An analogy would be making a distinction between a car and its engine. So, ORCP 79 analysis. With this constitutional analytical framework in mind, the court will turn to the requirement of ORCP 79A1A for a preliminary injunction, which these are just court rules. Quote, when determining whether to issue a preliminary injunction, courts consider, among other things, the likelihood that the party requesting the injunction will ultimately prevail on the merits of its claim, and whether, if the injunction is not issued, the party will be irreparably harmed during the litigation of the claim. Courts also balance the harm to the movement against harm to the opposing party and the public if the injunction is issued. Application of the law to ballot measure 114 must lead the court to a clear conclusion that these factors are met preliminarily. The preliminary injunction requires the plaintiff to meet the burden of production or persuasion by the providing evidence. The plaintiffs have produced such clear and persuasive evidence. The defendant's evidence bolsters the clarity of the court's determination. So we now look at the likelihood of success. Ballot measure 114 section 11 will dramatically change the rules on law-abiding citizens who currently own weapons or wish to purchase weapons with large capacity magazines. The vast majority of gun owners are responsible, careful citizens with a great deal of respect and care for their firearms and only use them for law purposes, including self-defense. The large capacity magazine provisions will go into effect unless the court issues preliminary injunction immediately, impacting their constitutional right to bear arms. Now we go on to the construction of ballot measure 114 section 11, as titled Prohibition/Exceptions to Large Capacity Magazines. And let's see, that section was attached as Exhibit 1 of the defense's response to plaintiff's motions for temporary restraining orders, so that's not going to be in this document. But we've already looked at it earlier when I pulled it up here. Anyway. The court will focus on specific language, but has considered the section as a whole. Section 11 prohibits any fixed or built into the gun or detachable external clips magazines that hold over 10 rounds of ammunition. Large capacity magazine means a fixed or detachable magazine, belt, drum, feed strip, helical feeding device, or similar device, including any such device joined or coupled with another in any manner, or a kit with such parts that has an overall capacity of, or that can be readily restored, changed, or converted to accept more than 10 rounds of ammunition. The prohibition has an exception for, quote, ammunition feeding device that has been permanently altered so that it is not capable now or in the future of accepting more than 10 rounds of ammunition. A new Class A misdemeanor is created for anyone who manufactures, imports, possesses, uses, purchases, sells, or otherwise transfers any large capacity magazine upon effective date. The ban does not apply to sales to the military or law enforcement. At least on-duty law enforcement. There's been suggestions that parts of this would interfere with off-duty police officers. Not touching our views on cops right now, but... Ballot measure 114, section 11, creates an affirmative defense to the crime. The accused would need to prove they possessed the large capacity magazine prior to the adoption of the measure. Then the accused would need to prove that their possession of the item was in use in specific ways and or kept in specific places. If they chose, owners could relinquish their property prior to the commencement or prosecution by arrest, citation, or formal charge. The court assumes that the investigative agency would have broad discretion as to when to arrest the individual, eliminating the option of just giving up the item. Again, if I had, if I was a relic collector and I had a bunch of M16 magazines from the Vietnam War, well, those are 30-round magazines. But if I've had them for 20, 30 years, do I have receipts proving that I had them from before December 2022? Unlikely. Unless they were like actual antiques that are traced. But Yeah, that proof is one of the big questions that I've had with this particular argument. This section requires licensed gun dealers cease sales immediately and within 180 days to alter or divest from all banned items. They'd have to either permanently modify them so they can never hold more than 10 rounds, or throw them away or destroy them, basically. I'm not even sure if they would allow for transfer out of the state. So now we look at the existence of large capacity magazines at statehood. The plaintiffs demonstrate that firearms with magazine capacity over 10 rounds of ammunition were in existence at the adoption of the Oregon Constitution in 1857. Article 1, Section 27 was adopted without any noted debate by the delegates. Claudia Brown and Andrew Gray, The Legislative History of Oregon, from the Willamette Law Review in 2001. The court infers from that silent record that no concerns were raised over the types of firearms allowed for self or state defense. The defendant does not point to any co-occurring Oregon statute prescribing large magazine firearms for citizens or any other types of weapons. The Oregon Supreme Court has held modern equivalence to the weapon today is, quote, substantially different from its historical antecedent, and that the drafters were, quote, aware that technological changes were occurring in weaponry as in tools generally. The court could not freeze the meaning of the state constitution to the time of adoption, but is instead to identify, in light of the meaning understood by the framers, relevant underlying principles that may inform the constitutional text to modern circumstances. The analysis of this court is that the framers and the population were aware of and even anticipating more powerful firearms, including with larger magazine capacities. The case law does not suggest that the firearms development is frozen in time at founding, as is argued by the defendants. In fact, the courts have assumed development over time. As such, the court finds the firearms today are the direct descendants of the firearms from the time frame of statehood, multi-shot handguns and rifles. The type of magazine is essential to the protective power of the firearm, as was testified to by one of the defendant's witnesses. The precedent in Oregon shows no historical statutory bans on the size of magazines or on the types of firearms until 1933. All preceding restrictions were on use, such as prohibitions on riding horses through town terrifying neighbors with firearms. The right to bear arms included military firearms used for state and self-defense at the time the provision was drafted. And they go back to State v. Kessler here. The court held, quote, firearms and other hand-carried weapons remained the weapons of personal defense, but the arrival of steam power, mechanization, and chemical discoveries completely changed the weapons of military warfare. The development of powerful explosives in the mid-19th century, combined with development of mass-produced metal parts, made possible the automatic weapons, explosive, and chemicals of modern warfare. Automatic weapons are banned in Oregon, as are other military-grade weapons. Which seems to suggest why we're not questioning the machine gun ban, because that was a whole new type of firearm that was not likely to be at the forefront of the state constitution framers' minds, because it was, it was stuff that was just starting to be created, much less to the average person or military use. Now, there's also something here about Kessler's subject matter was billy clubs and not firearms. All discussions regarding firearms is dicta. As noted, large capacity magazines predated the automation and mass production of metals. Large capacity magazines existed in the 1830s, nearly 200 years ago. The type of firearm with a large capacity magazine was known and used for self-defense at statehood, and would have been understood to be a firearm being developed for militia usage and self-defense. Got a couple new references here. Kessler found the terms arms in Article 1, Section 27 are weapons used by militia and for self-defense maintained by the individual. Kessler also announced that regulation is valid if the aim of public safety does not frustrate the guarantees of the state constitution. And the defendants have not shown that large capacity magazines are, quote, advanced weapons of modern warfare. The court weighs that assertion against the ubiquitous nature of large capacity magazines in distribution to the public. So, go on to the court finds that magazines indistinguishable from the firearms they power and are protected weapons, and ballot measure 114 section 11 acts on a prohibition of firearms and their protected use under Article 1 section 27. So now we go on to a public safety question. President Barack Obama eulogized to the Sandy Hook families in Newton, Connecticut a decade ago. The court echoes, I am very mindful that mere words cannot match the depths of your sorrow, nor can they heal your wounded hearts. The court is incapable of improving on that important, profound sentiment. The defendants concede the ballot's measure's intention is to reduce mass shootings. Mr. Marshall for the defendants is right that mass shootings deliver a special type of terror in our heart and minds, and that the majority of voters in Oregon believe that banning large capacity magazines would help to relieve a, quote, grave and immediate risk to the health, safety, and well-being of the citizens of the state. And this was from the preamble of the ballot measure. Fortunately, the facts do not support their conclusion. Quote, judges must not be intimidated into upholding the majority rule. Judicial independence and judicial accountability are both shields and swords, but both are intended to protect judges and to allow them to fairly decide all cases and ultimately to protect the rights of every person. Oregon Constitution allows for reasonable restrictions to promote public safety. The promotion of public safety cannot be based upon a merely speculative harm. Section 11 does not restrain dangerous practices or regulate the carrying or use of firearms, only the possession of a ubiquitous weapon design. Any restriction must satisfy the purpose of the authority in the face of Article 1, Section 27, the protection of public safety. While the preamble of the ballot measure states it promotes public safety, the court finds from both sides' pleadings and exhibits it does not do so in any measurable way. Their primary article states the restrictions on large capacity magazines seems to have an effect on the outcome of mass shooting events, but the sample size is too small to say definitively, referencing factual finding 17. Correlation does not equal causation. Further, the court finds there is a less than 1 in 1 million chance of a person being a fatality in a mass shooting in Oregon, and even less with an offender who is using large capacity magazines. They go on to reference here, large capacity magazines are used in 3 out of every 10,000 instances of self-defense outside the home, a constitutionally protected activity. Okay, that clarifies the question I had before. If they're focused on self-defense outside the home, where somebody is carrying, say, a concealed carry weapon, that may be a smaller gun, smaller caliber, fewer rounds, and that might be why they're saying, you know, you'd have a personal carry and a home defense firearm. So that is starting to make a lot more sense now. So there is no analysis of such use when defending the home. Ballot measure 114 section 11 makes it illegal to possess large capacity magazines in the home unless the accused provides affirmative proof of ownership prior to passage and that the possession met one of the exceptions under the law. The large capacity magazine bans promote public safety is mere speculation. Defendants argue that every mass shooting since 2004 with 14 or more deaths uses large capacity magazines. They fail to note that there have been 10 such events in the last 18 years, as is borne out in their exhibits. There have been 110 mass shootings of 4 or more victims in the same time frame, many of which did not include large capacity magazines. That sounds like they cherry-picked the heck out of their data. Honestly, they 14 or more seems like a very specific number of deaths that if I was to look at the raw data, I suspect they did that to support their use of how often high capacity. The court cannot sustain a restraint on the constitutional right on mere speculation that the restriction could promote public safety. Certainly, a court cannot use a mere speculation in determining the guilt in a criminal case, damages in a negligence case, future harm in a parole matter, or the many other legal matters we're disallowing that outcome. And they reference a Prosser on torts expresses, what is required is evidence from which reasonable men may conclude that, upon the whole, it is more likely that there was negligence than that there was not. Where the conclusion is a matter of mere speculation or conjecture, or where the probabilities are at best evenly balanced between negligence and its absence, it becomes the duty of the court to direct the jury that the burden of proof has not been sustained. In other words, it need to be more likely true than not. And here the judge is saying, based on the evidence, finding much less likely that it's true than not. If more than a passing suggestion. Firearm owners deploy more than 10 rounds in 3 out of 10,000 legal acts of self-defense, which is frequency of 100 times higher than any chance of fatality from a mass shooting. The right to bear arms in self-defense is constitutionally protected and is presumed to protect public safety using the current technology of the day. So yeah, you're more likely to die in a self-defense shooting than a mass shooting. Ballot Measure 114, Section 11, does not reasonably promote public safety, meaning it is not a permissible legislative regulation. Therefore, it is facially, on the face, unconstitutional prior to analyzing how unduly burdensome the measure is on firearm ownership. Defendant's analysis on page 11 regarding regression analysis overstates their own literature significantly. Their own literature states that there seems to be a correlation as hypothesis due to the very small statistical size and the incompleteness of the literature, going back to number 17, which I saw then that it was statistically questionable. Magazine size is a regulation on a firearm. That regulation must reasonably promote public safety. Large capacity magazine prohibition has not been shown to promote public safety in a calculable way beyond the protection already achieved by the status quo. The court cannot read Section 11 in any way that creates a constitutional act. And unduly burdensome. Even if Ballot Measure 114, Section 11 is a reasonable restriction, it cannot unduly frustrate the right to bear arms. Section 11 restrictions on current gun ownership and future purchases unduly frustrates the right to bear arms under Article 1, Section 27. Considering the testimony of Callaway, Yergalatis, and Defendant Busey, most commonly sold firearms can be adapted by interchangeable magazines to hold more than 10 rounds. Most, if not all, magazines are readily modifiable to hold more than 10 rounds. Magazines are necessary to make a firearm operable. A plain reading of Ballot Measure 114, Section 11D, makes the sale, possession, or transfer, except upon death, of those firearms punishable by crime. Those firearms with magazines are capable, now or in the future, of readily restored, changed, or being converted to accept more than 10 rounds. Based on the preliminary evidence, the result of Ballot Measure 114 would be a near absolute prohibition on handguns and many firearms with their magazines. That seems very important. Ballot Measure 114 is tantamount to a total firearm ban on many categories of guns. Further, the Court of Appeals rejected the notion of modification to make a firearm legal after the fact. While it is argued by the defendants that firearms can be modified to meet the requirements of Ballot Measure 114, the law does not support that proposition. The dissent concludes that because the semi-automatic firearms may be illegally modified to become automatic weapons is not a reason to deprive them of Section 27 protection under the tests adopted by the Supreme Court. That is backwards. The weapons have been modified ostensibly so that they will not be classified as military weapons, which under the Supreme Court's tests are not entitled to the constitutional protection. These modifications cannot be used to bootstrap these weapons into personal defense weapons so that they come within the constitutional protection. The weapons are not the sort of weapons for defense self-intended by the drafters to come with Article 1, Section 27. So this was referencing a 1993 case, Oregon State Shooting Association versus Multnomah County. I'm not entirely sure the context of it, but I mean, it definitely is talking about, converting semi-automatic weapons to becoming automatic weapons, which is something that is definitely a can-be-done kind of thing. Anyway, so Section 11 provides no definition on how such a modification would be permanent in the eyes of the law. There is a restraint on purchase, transfer, and possession of firearms with large capacity magazines, fixed or detachable. Any firearm that can be modified to hold a large capacity magazine is also prohibited to be sold in the state of Oregon. If a future kit is developed to modify a current model of magazine or firearm, that model would become immediately prohibited under Section 11. Kits can be used to expand fixed magazines. Most, if not all, firearms requiring detachable magazines will be unusable and unpurchasable under Ballot Measure 114, Section 11. Since most, if not all, detachable magazines can be readily restored, changed, or converted to accept more than 10 rounds, those cannot be sold under this law. Ballot Measure 11, 1D. See factual findings 24 through 29. There is no other way to read the provision that would make it facially unconstitutional. The or component language restrains the number of firearms that can be sold to less than 10% of what is currently on the market. Current owners of large capacity magazines are criminalized under the law. As I said before, based on numbers they put here, it's about 20% of the Oregon population. As is pointed out by the plaintiffs, Ballot Measure 114 provides no general exception even for continuing to possess magazines already owned prior to the effective date. Rather, it provides a mere affirmative defense. If found with a large capacity magazine, the owner has a choice of relinquishing the magazine without further process or face arrest at an officer's discretion. Officer's discretion. That sounds like the possibility of some implied bias. You find a conservative white guy with a 15-round magazine. A cop might just let him go with a warning. Don't let us see that. You find a black guy with a pistol that's got 15 rounds. Nope, arrest him, charge him. So anyway, once arrested and criminally charged with a Class A misdemeanor with a maximum penalty of 364 days in jail and a fine up to $6,250, the accused can exercise an affirmative defense proving the possession of the large capacity magazine prior to passage of Section 11. An affirmative defense places the burden on the accused to prove their right to possess the large capacity magazine by a preponderance on the evidence. Proof may be testimony subject to credibility determination by the fact finder, but is generally better bolstered by documentation. All of the exceptions to the crime in Section 11C are also part of an affirmative defense. The accused must establish proper storage on the private property of the owner or while engaging in public or private shooting range or hunting, and if they were transporting the magazine, it was in a vehicle lockbox. In other words, the possession is presumed illegal until the accused owner of the large capacity magazine proves otherwise in a court of law after the state has established a prima facie case of guilty by surviving a motion for judgment or acquittal. Defending a criminal charge is expensive, time-consuming, and extremely stressful with private legal counsel. Side note, as we've seen, especially in Multnomah County and across the state, public defenders, we have a bit of a shortage. I mean, how many cases has Multnomah County all of a sudden dropped because there's not enough public defenders to, allow for our constitutional right to representation? Let's see. All indigent defendants would face the same challenges, except they would be entitled to court-appointed counsel. Oh, and here he even says it. The public defense crisis is playing out throughout the state. This, too, is exponentially worse in rural areas for a wide variety of reasons. Oregon State Bar President Cameron Graham. Rural Oregon needs our engagement. Rural Oregon is a place with a rich culture of firearm ownership and pride in their capacity to handle their use without interference. In other words, counties like this county here are going to be even more hit if the police were to enforce this measure. So now we all circle back to preliminary conclusion on the likelihood of success. Under these findings and legal analysis, there can be no reasonably likely circumstance in which an application of Section 1 or Section 11 would pass constitutional muster. The statutory scheme is very burdensome on lawful firearm owners who possess large capacity magazines legally now. Clear from the preliminary record, magazines capable of holding more than 10 rounds come standard with many popular firearms and firearm platforms on the market today and are possessed by law-abiding citizens for lawful purposes. The measure criminalizing current lawful conduct, creating presumed criminals out of 1 in every 5 Oregonians. In other words, under Christian, the regulations are unduly burdensome on currently lawful conduct and are without a public safety promotion. The court is clearly persuaded the plaintiffs have a likelihood of success on showing Section 11 is unconstitutional under Article 1, Section 27. The court will not turn to the federal Constitution. Imminent and irreparable harm. Plaintiffs show implementation of 114 would, if their challenge is successful, cause an irreparable harm to gun owners and those seeking to purchase firearms for self-defense. Any deprivation of a constitutional right, even temporarily, constitutes an irreparable injury. The plaintiffs have shown that there is a likelihood that the court will find the section facially unconstitutional. There are no circumstances where the section could be constitutional. The defendants state as a practical matter, plaintiffs can continue to, quote, keep and bear arms. Defendant's response. Defendants even argue that, quote, both firearms and magazines are durable goods with a long, useful life. Plaintiffs can continue to keep and bear the arms they currently possess. There is no analysis for the defendants on how many mass shootings use large capacity magazines, how many of them were newly purchased. The evidence is also that fixed plate magazines do not have a long and useful life. The long and useful life relies on the ability to remove the base and floor plate for regular cleaning, which, as I pointed out before, is the only feature that you need, really, to be able to modify a magazine to shoot more than 10 rounds, or to hold more than 10 rounds. On its face, that statement may seem persuasive, but that is borne by the facts. The state can only fetter the right to bear arms with a clear showing that the regulation promotes public safety and is not unduly burdensome. Section 11 fails to meet either legal standard. Defendants have not shown how delaying implementation would cause imminent and irreparable harm. This is particularly emphasized by the delay in implementation of the Permit to Purchase program. The status quo is not improved by implementation of Section 11. And the Permit to Purchase program, like I said, that got put on hold indefinitely because the state can't even get the system up and running yet. So now we go to looking at balancing harms. There is little to no harm in delaying implementation of Measure 114 while the parties prepare and present evidence at an injunction hearing. Based upon the court filings, there is a clear preliminary showing of an irreparable harm to the right to bear arms under Article 1, Section 27, under Section 11, providing a mere speculative harm of allowing the ongoing possession and purchase of large capacity magazines. The numbers are starkly in support of this preliminary determination. If allowed to go into effect, 1 in 19 of all Oregonians are presumed guilty of a Class A misdemeanor unless they can prove otherwise. More than 10 rounds are needed in 3 out of every 10,000 acts of legal justifiable self-defense acts. The chance of being a fatality in a mass shooting in Oregon is 0.3 in a million. There have been 13 mass shootings with 14 or more fatalities since 1966, a very low number with naturally high emotionality responses. Finally, the defendant's own literature seems, in quotes, to show that the ban will help with fatalities. No definitive scientific evidence has been provided that large capacity magazine bans have any impact on the number of fatalities or casualties now or in future events. The implementation of Ballot Measure 114, Section 11, would have an immediate impact on the liberty interests of 1 in 5 Oregons and make it harder for the weaker individuals in our society to defend themselves against attackers. And we go to the public interest standard. The legal standard here is there are situations where the public interest would be so seriously affected by the issuance of an injunction that the court will deny an application therefore. And this is referencing Elkhorn Baptist Church v. Brown, which is quoting another case from 1951. As described above, the public interest in this matter is real and significant. The people of Oregon voted for the measure by a margin of 975,553 for the measure and 950,589 against. And that was from the Secretary of State website. The court acknowledges the proponents demonstrated that our society has become exacerbated by the relentless news about mass shootings in the country and the slaughter of innocents. However, there is strong evidence presented by the proponents of Measure 114 that public safety is not promoted by the exercise of the authority contained in the measure, and the measure unduly frustrates the right to bear arms, making it unconstitutional. There is a nearly equal public interest in issuing a preliminary injunction. There is a serious harm to the public interest as well when individuals are arrested, prosecuted, and convicted of a Class A misdemeanor under an unconstitutional statutory regime, a potential if Measure 114 is allowed to go into effect at this time. A delay for judicial review of the constitutionality of the measure outweighs immediate implementation subject to potentially overturning the measure after review. The public interest demands judicial scrutiny and deliberation to avoid a seesawing back and forth on this issue. A final determination needs to be made on the constitutionality of the measure prior to lifting any injunction. On balance, the public interest in implementation of Ballot Measure 114 weighs in favor of the preliminary. Conclusion. The court orders the temporary restraining order remains on measures 1 through 10. Upon receipt of notice from the defendants, the permit to purchase process is administratively ready. The court will hold a preliminary injunction hearing within 10 days, unless fixed by the court on a different date, to determine if the program can be constitutionally implemented. So, this is talking about a different section that we haven't really talked about, but the permitting part, they're telling the state, get your stuff together that this ballot measure wants. Once you're ready, we'll go back and look at, is this going to be constitutional the way that this permit program is structured? They need more information before they can say it. They need the ability for it to be run and then they need to make sure that the way that it's run is lawful. The next hearing related to background checks will be on December 23rd at 10 a.m., as noted above. And this was talking about the Charleston loophole, I believe, was the focus there. The identified statutory provisions of the law subject to that review will be filed by defendants in writing by December 16th at noon tomorrow. And the court orders a preliminary injunction is granted as to Measure 114, Section 11, until a full hearing on the complaint can be heard, whether the court can determine by clear and convincing evidence whether it is constitutional under Article 1, Section 27. Plaintiffs shall prepare each order separately and submit them by December 16th, which is just the plaintiffs write up the specifics of what needs to be said legally. The judge signs it off. That seems to be a thing that happens often, because they understand the specifics more, a little bit more nuanced, I guess. And that is Judge Robert Rascio, the presiding circuit court judge in Harney County. So I think it's obvious by this point that I was not a fan of 114 when it was released as a I think this was IP6 back when it was in the signature stage. It was facing a major uphill battle just to get the signatures to make it onto the ballot until Udeville happened. The mass shooting in Texas, it seemed to galvanize this group, and they were able to get the signatures they needed to get it on the ballot. I expressed frustration at the time because, while I recognized that shooting was horrific, the police and Border Patrol and everything, the response to that was incompetence is too nice of a term. But the way that it was politicized by the proponents of this measure in Oregon to get the signatures that they needed honestly sickened me. It felt like those kids became a prop to get what they wanted. And, you know, as we're seeing here, based on what one would think was they brought their best evidence to this injunction hearing, and their best evidence was riddled with errors and logical fallacies, and in many ways just straight out wrong. Yeah, Melissa was saying it was criminal, and one congressperson is calling for a federal investigation. Yeah, there better be. I mean, Portland has, in the last few years, had a very troubled past with Border Patrol, and, you know, a lot of us have a lot of problems with cops in general. But, you know, for the one thing that they're supposedly supposed to, you know, it's like the saying, you had one job. This is supposed to be their one job, and to just fuck it up that badly. And when you've got parents, unarmed parents, busting past the cop blockades to run in and try to save their kids, while all the cops with all the guns and everything are just standing around on their phones like, I don't know what to do because, But anyway, so yeah, the way that tragedy got politicized here to get those signatures sickened me. Now, I know that Yeah, and you know, like Melissa was saying, the hearings yesterday and today with some of the victims and survivors were heartbreaking. That is definitely. I mean, anytime you have someone that's been a victim of trauma, that is. I don't even. I feel like any words that I might have to say are just going to be hollow, but yeah. But yeah, I just, the proponents of this measure, I used to get where they were coming from. I used to think that, we've let gun culture get too much, and maybe we shouldn't have guns. We don't need guns. Look at other countries that, um, Australia. They had one mass shooting. They passed extreme gun laws, and they haven't had a mass shooting since. I used to be one of those people that thought, that's good, but now it's like, uh, in a country like this, we've been pro gun since day one, and even if some states ban guns, obviously that's not going to fix anything. We talk about issues of New York having strict gun laws, but then you just have people coming from neighboring states with their guns and just quote unquote smuggling them in. That was probably what was about to happen in Oregon here. You know, Washington, Idaho, Nevada, bordering states that have pretty loose gun laws, or relatively. Hell, even California's got looser gun laws than was suggested here. Um, just doing bans isn't going to fix the problem. We need to be smarter about what we do. Smarter about how we address these issues. Let's look at the science. Let's look at where these things are coming from. The judge pointed out suicide, domestic violence, red flag law violations. I mean, red flag law violations, those are, I'm not entirely sure what they meant by that, if there were ones where somebody had the red flag was up on them and they didn't turn in all their guns, or if they did something before turning in, or, I'm not entirely sure what the specifics on that were, but between suicide and, domestic or intimate violence, I've already pointed out that most, if not all, of 114 isn't going to address any of that. So what will? Suicide is almost always has a mental health start. That's usually what causes that. So let's work on mental health. We just passed a ballot measure to write into the Constitution guaranteeing a right to health care. Now, we don't entirely know what that's going to mean yet legislatively, but let's work on improving the things that we know can improve life in general. Do we know that adequate mental health treatment that's affordable for everyone in the state, do we know that's going to solve suicides? No. We have a good idea that it's going to have a positive impact on it, and as we go, the science can then bear that out one way or the other. Let me see, Melissa. One congressperson today made the comment that you shouldn't take away guns if someone is suicidal. because they can find another way to kill themselves. It was a poor argument. I mean, yes and no. I don't talk about this often because, I'm not trying to garner sympathy, and I imagine it's not the kind of thing most people want to hear, but I've had suicidal plans myself in the past. I haven't had access to a gun, and my plan was... Oh, you're fine, sweet. Sorry, the deaf cat gets very vocal sometimes, so I'm just making sure she knows that I hear her. But I definitely had a plan. I probably could have pulled it off. I was stopped before, I was talked down, and a few days later I was able to get into a hospital to get the help that I needed, and those few days were, some of the worst days of my life, but the after effects of them ended up being one of the best things that ever happened to me, because I was able to get the help that I needed. I was able to get that stabilizing care, the support that I needed for the things that were causing me to feel like I had no value to society, to other people, that I was only a burden, and why am I existing to leech off of everyone? I'm not providing anything. I had no self-worth in myself. So it seemed like it just made more sense for everyone if I wasn't here. And like I said, it was a poor argument, but it is still an argument. You take away a gun, there's going to be a knife. We have... Look at the UK. They have very strict gun control laws, and then they had a problem with stabbing. So now they've done knife control laws where you have trouble going out and buying kitchenware because, in some places, because of the legal requirements based on that. There is a certain risk in life. We're not going to be able to save everyone from everyone as much as we want to. But, and they looked at numbers here. Some of them don't intellectually seem right to me, but I don't know the science. But they pointed out, such a low number of people at risk from a mass shooting, and we compare it to how many people we lost from, people not trusting the science on COVID. We had people that were going to pass away from COVID anyway, but how many less it would be if we had taken masking and vaccination and everything seriously. So, I'm glad that 114, as it is right now, everything is still on hold. We have this preliminary injunction on this part, which means it's going to be there for a while. The background check loophole, we'll find out more on that towards the end of the month. It'll be out in the news. Um, and yeah, that's. We'll see where things go. It's going to take some time to go through. There may be, depending on how the. I have a feeling, however this court rules on it, it's going to be appealed, because I have heard that incoming Governor Tina Kotek, even if 114 had not passed, she wanted to do as a lot of similar stuff to it legislatively. So it would not surprise me if the state was to appeal, even if 114 was found unconstitutional. So this is going to be, the earlier chapters in a long-term debate. And I can see where there may be needs for some restrictions. 114 was not the way to do it. It left a lot of situations at the discretion of local leaders and law enforcement, which would have made it very easy for, say, conservative areas with law enforcement that might be more likely to support white supremacists, letting fellow white supremacists and conservatives have guns going through the permitting process, whereas more liberal areas might be more likely to deny those to minorities. People of color, indigenous people, members of the LGBTQ community. And that's a whole other set of issues that I had personally. That being said, I'm not sure that there's really anything else that I have going on with this right now. Like I said at the beginning of the video, we had a lot of stuff going on over the last few weeks with the holidays and everything that screwed up our plans. Between Holo, one of our cats passing away, and getting sick, and all that stuff, which I'm glad, I've been talking for a couple hours now without having too much trouble, which is a good sign for me. We're hoping to, in the coming weeks, try to play more catch-up. A couple of things that we do have going on. We've got a new sub-website on the Raindrop Works site that is still being a little better organized, but court.raindrop.works is our new site where we are listing information from court cases. Found out that organizing the information in a Wikipedia type format is a lot easier and looks a lot nicer than trying to do it on a web page, on a regular web page like we were doing before. And it's faster. So we're trying to go through and play catch up on all of the cases that we have coming up in the coming months. Work on starting to get down all of the documents and up onto the new site. We've been making some social media moves because of the concerns that we've had with new Twitter owner Elon Musk and his apparent concerns with journalism freedom. So we've been working on the inevitable concerns of getting banned for spurious reasons. And just still playing catch up with other projects to keep an eye out. We'll still have the more videos coming out on our YouTube channel here. Definitely thank you all for tuning in and joining us. Down in the links in the video description here, we do have our link tree, which links access to our sponsors and Patreon if you want to support the work that we're doing financially. It definitely, there is a cost for us doing all the work that we're doing here, and if we can help with getting some of that offset, because fixed income, there's limits to how much we can do, and would like to be able to do more. In the meantime, we have had our longtime supporter, Miss Betsy. She's been, almost since day one, has been supporting us over on Sponsus, and definitely can't thank her enough for that. But in the meantime, I think this is what I've got for now, probably for the weekend, because the rest of this week's going to be pretty busy. But y'all take care of yourselves. Try to take care of each other. Have a good weekend. Have good holidays. See you later.